Welcome back, warriors. Today's video is a request by some of my social media friends who wanted to know my opinion on Bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous Peoples, otherwise known as UNDRIP. So if you want to learn more, stay tuned. On Monday, May the 10th, I appeared as an individual at the request of the Senate Standing Committee on Aboriginal Peoples to share my views on Bill C-15 and UNDRIP and help answer questions from senators. I did not speak on behalf of any group or organization, but rather as an individual expert witness who has experience working in First Nations laws as well as Canadian and international laws impacting Indigenous peoples. In today's video, I'll be sharing my testimony at Senate so you can hear my opinion in my own words. The clip that I'm going to show you is an excerpt from yesterday's APPA committee meeting, which was in session for most of the day. Therefore, I edited the clip to include just my testimony and all of my answers to the questions asked by the senators. But before we show the clip, I've also been asked to provide a brief overview of my background. This way you can better understand the context from which my insights and analysis originate. Kwe Nindaluizi Pampometer, and I come from the sovereign Mi'kmaq Nation in unceded Mi'kma'ki. I'm a member of Ugbaganjig, which is also known as Eel River Bar First Nation in northern New Brunswick, Canada. I come from a huge extended family who taught me about the social, cultural, political, and legal elements of our Mi'kmaq Nation, as well as our culture, traditions, ceremonies, laws, relationships, and responsibilities to our nation. I'm thankful to my extended family and relations all over Mi'kma'ki for ensuring that I'm able to benefit from lifelong traditional Mi'kmaq education. I have worked with Mi'kmaq communities and other First Nations communities, organizations, and grassroots groups all over Canada, on and off reserve, for more than 30 years, always advancing our individual and collective rights and responsibilities, as well as defending our sovereignty and our territories. In addition to my traditional Mi'kmaq education and practical working experience with Mi'kmaq communities and other First Nations, I also had the benefit of post-secondary education. I have my Bachelor of Arts in Native Studies from St. Thomas University, my law degree from UNB, and my Master's and Doctorate in Law from Dalhousie University. As a result, I've been a lawyer with the New Brunswick Bar in good standing for 23 years. And during my grad studies, I worked with Justice Canada and Indian Affairs on a wide variety of files related to the Indian Act, reserve lands, Indian registration, as well as treaties, claims, and self-government. My role was always as an advisor and never as a litigator. I currently work as a full professor and the chair in Indigenous Governance at Ryerson University, and I've spent more than a decade appearing before parliamentary and Senate committees, as well as United Nations human rights treaty bodies, speaking to the impact of Canadian laws and policies on First Nations. So hopefully that answers all of your questions about my background and experience and the kinds of diverse knowledge systems that inform my insight and analysis on Bill C-15 and UNDRIP. So let's roll the clip.
Now I'd like to call upon Dr. Palmater for her opening remarks.
Thank you very much, Senator. Kwe Nindaluizi Pampometer. I'm from the sovereign Mi'kmaq Nation on unceded Mi'kma'ki. And I'm a member of Ugbaganjig, Eel River Bar First Nation. I've been a practicing lawyer for 23 years, 10 of which was spent at Justice Canada and Indian Affairs, where I was trained in the legislative process, legislative drafting, and statutory interpretation. And my current work since has dealt with laws and policies impacting First Nations and international human rights legal obligations. With regards to Bill C-15, I echo the submissions of Professor Gunn and Professor Napoleon. I am in favor of passing Bill C-15. It's long past time that Canada took the necessary steps to implement UNDRIP into domestic law. Indigenous peoples all over the world, including First Nations communities and organizations, have continually called on Canada to implement UNDRIP, and it is because of their work that UNDRIP even exists. We know from the TRC multiple calls to action, calls number 43, 44, 45, and others speak specifically to the centrality of implementing UNDRIP as a form of reconciliation, not just implementing UNDRIP, having the National Action Plan, but also repudiating any concepts like the doctrine of discovery and terra nullius that have been used to justify assertions of sovereignty over Indigenous lands. We also know from the National Inquiry that their very first calls for justice require that Canada develop a national action plan to end genocide, which includes specifically the implementation of all international human rights instruments, including some of those already mentioned, like the Convention on the Rights of the Child, the elimination of discrimination against women, elimination of racial discrimination, and UNDRIP. But not just those conventions and declarations and treaties, but also all of the recommendations that have been made by those human rights treaty bodies to have Canada end the ongoing grave human rights violations. And why? Because despite all of Canadians' federal and provincial and territorial human rights laws, Charter of Rights and Freedoms, and Section 35 protections for Aboriginal and treaty rights, Canada honors our rights more in the breach than in the implementation. Why? Because Canada is an outlaw. It's a state perpetrator of historic and ongoing genocide. Canada's laws and legal precedents and whole legal system is why we have an ongoing genocide, why Indigenous peoples are dying. It's the absolute intention of UNDRIP to change the law. And we only need to look at the recent letter from the United Nations Committee on the Elimination of Racial Discrimination that called on Canada to account for failing to protect the rights and safety of Mi'kmaq people to fish and govern their fisheries. We know that all of the governments and institutions and some segments of society and industries suffer from systemic racism, which results in real harms to Indigenous peoples. Canada's current legal system and laws do not protect Indigenous peoples. We also know that Canada's failures, even their policy decisions, are made every day, where choices are made to violate human rights in order to maintain and protect the status quo that has privileged and benefited so many people for so long. Incredibly, these decisions have been made in the face of all of the horrifying statistics about the rates of kids in foster care, murdered and missing Indigenous women and girls, incarceration, homelessness, and violence. So on the question of do we need UNDRIP to be implemented into Canada's legal system? Most definitely. Like all international human rights obligations, states should always take steps to implement them. Will C-15 help us move in the right direction? Yes, it will. Every human rights instrument that we have is a tool to protect the human rights of Indigenous peoples that are not being protected right now. Do I trust governments in Canada to interpret, implement, and respect the rights? Absolutely not. We only know from history they will fight us every step of the way. But that's the next stage. We need the first stage to have the tool with which to defend our human rights. Does Bill C-15 and UNDRIP hurt Indigenous rights in any way? I don't think so. Both documents contain specific provisions saying that there will be no abrogation or derogation of these rights that already exist. You don't need yet another provision to say that again. I think the first step is passing Bill C-15 to give us one more tool to fight the Goliath that is Canada's genocide machine. Even though the bill itself might not be perfect, if you gave it to me as a legislative drafter, I would include a whole bunch of other provisions. I would put in lots of clarities, include things that should happen during the National Action Plan. But I think the most urgent situation we have before us is to get UNDRIP incorporated into Canadian legal systems and ideologies and judicial interpretation, and we can work out the vast majority of issues during the National Action Plan. And I also think that Canada has to lead at the federal government level. How can we call on provinces to do the same thing if the federal government isn't prepared to do this? And I would hate to see this bill be held up in Senate, like with Bill 262, when we're talking about the basic human rights of people, the right to life, the right not to be killed and targeted by police officers, the right not to be sexually assaulted and exploited by police officers, corrections officers, social workers, and teachers. We have the right to say no to violence.
Senator Patterson.
Thank you, Madam Chair, and thanks to the witnesses. Dr. Palmer, welcome back to our committee. I'd like to ask you, you mentioned amongst the many injustices against Aboriginal people, you mentioned the Mi'kmaq issue. Marshall 1 and 2 Supreme Court cases say that the Minister of Fisheries and Oceans can manage the fishery, which could include imposing restrictions. However, as we know, those restrictions on such things as seasons have been rejected by the Mi'kmaq. And I'm not trying to take sides, but I would like to ask you this. Is it your position that C-15 will compel Canada to ignore those Supreme Court decisions?
Thank you for your question, and it's a really important one. I think what C-15 will do is require that Canada bring all of its laws into compliance with UNDRIP, and that includes all of the human rights protections within UNDRIP, which includes the right to govern our territories, govern our resources, govern our peoples in accordance with our laws, and in partnership with other levels of government where that comes to a negotiated settlement. And it also requires that the courts will have to take into account the full spectrum of human rights protections that they don't now take into consideration. The courts very much look at fact-based, precedent-based, but just because the common law is based on precedent doesn't mean that it's right. I mean, the whole purpose of the Constitution as a living document is to evolve over time and change the law and recognize that laws and legal values and principles in any legal system, even a multi-juridical one, changes over time. Imagine where we would be if we had given in to the fears of men, where women were asking for equality in the law. Imagine if we gave in to the fears. I mean, it was literally, they were predicting doomsday if we allowed women to have the right to say what they do, the right to vote, the right to participate in government. And so we're in a situation here where we've so normalized racism and dispossession and oppression within the very elements of not just our government's institutions and laws, but even in the way we think about what's good and not good for the country. Imagine even having to have a discussion that recognizing the bare minimum human rights of Indigenous peoples could somehow be a problem.
Senator Francis.
Thank you, Chair. Some of you have already spoken to this question, but I want to give you an opportunity to elaborate further if you like. Would you agree that the Supreme Court of Canada's interpretation of Section 35(1) of the Constitution Act has failed to reset the colonial relationship between Indigenous peoples and Canada, especially by failing to understand Indigenous peoples' rights according to their own legal traditions? If so, could the framework proposed in this bill to bring our domestic laws and policies into alignment with the United Nations Declarations on the Rights of Indigenous Peoples help address this disconnect? And what impact could it have in the interpretation of constitutionally protected Aboriginal and treaty rights? Maybe I'll get my fellow Mi'kmaq friend, Dr. Palmer, to start off.
Well, Alan, that's a really important question. And not only has Section 35 failed to reset the relationship, it has reinforced the unbalanced, oppressive relationship that exists. In all of its court cases where they purport to give you a win, but there's always some limiting factor in there. There's always the presumption of sovereignty, always the presumption of control, always the presumption of paramountcy. And that's where the problem lies. And I guess the real question is Canada working right now? And you can't say yes because we are in an ongoing genocide. Canada is a state perpetrator of genocide. So that means you have to look at the totality of incremental amendments in all these different laws and policies, all of the different court cases under Section 35, and say, has that helped move us out of genocide? And in fact, on many socioeconomic indicators like incarceration, murder, missing, foster care, everything continues to get worse. So we need something that will reset the relationship. And if you look at UNDRIP, although some people are fearful of it, UNDRIP is just the bare minimum standards of human rights that will bring about the health, safety, well-being, and dignity of Indigenous peoples that, like Professor Gunn said, is already represented in a whole host of other declarations and treaties that Canada is bound by. So we shouldn't be afraid of it. We should welcome the protecting of human life, welcome self-determination, welcome peace and stability on these territories and working together, which is what the original treaties envisioned, which isn't what happened.
Great answer. Thank you, Dr. Palmater.
Senator Pate.
Thank you, Mr. Chair, and thank you to the witnesses. My question is for Dr. Palmater. Recently, I listened to a podcast where you discussed Bill C-15 with Ellen Gabriel, and you and Ellen talked about the fact that the UN Declaration is seen as outside the scope of the Indian Act and Section 35 of the Charter. And I'm interested in your take on is Bill C-15 meant to change the law, and how will it address or impact the genocide that you discussed earlier today and that you discussed on the podcast?
Thank you so much for the question. I think that's why we're here. We are trying to change the law and all of the policies that attach to the laws and all of the regulations that attach to those laws and policies and all of the economic and governing systems and the way systems work. That's exactly why we're here. If there is no intention to change the law, then, and this is just some sort of political pat on the back, yeah, you have human rights, just not here. I mean, we shouldn't even be having this discussion. But the fact that we're here now having this discussion should make us realize that, people who defend so-called well-settled jurisprudence is really defending well-settled injustice, well-settled breaches of human rights, of treaty rights, of Aboriginal rights, of even the life and safety of people. And so, we're talking about a system of injustice, racism, and genocide. But UNDRIP offers something different. UNDRIP says if our relationship is based on just basic minimum human rights, that by the way, most other people get to enjoy. But if Indigenous peoples' basic human rights are represented, we can move forward in a collaborative way without the fear that's attached to negotiations. That if we don't agree to whatever's put before us, they're sending in the RCMP and they're sending in the army and they're going to incarcerate us. That's not a negotiation. And I think we have to, really remember that reconciliation is going to be painful. We are going to be pushing people out of places that have power, privilege, and wealth based on our ongoing dispossession, and trying to reset the relationship more in the spirit of the treaties, where we both belong, where we both prosper, where we all recognize each other's rights. And so, yes, it should change the law in very significant and substantive ways, no matter what federal officials have to say. That's the whole purpose of it. That's the whole purpose. Section 35 hasn't done that. And in fact, we have lots of problematic court cases around Section 35 that need to be reconsidered. How can we possibly get those reconsidered without something fundamental like UNDRIP that says human rights are the bare minimum?
Dr. Palmater.
Thank you.
Senator Hartley.
Thank you, Chair, and thank you, witnesses, for being with us today and learning a lot of new things. I have a question for perhaps Dr. Palmater and maybe Mr. Madden. I'm living on the unceded territory of the Mi'kmaq people here in New Brunswick, and I'm thinking about some practical examples of things and wondering if we had Bill C-15, how would that change these issues? So one of them is the issue of, in Elsipektu a few years ago, we had the issue of the fracking, and the people had to really stand up to that. And it took a very long time to get it settled, and they went through a lot. And so I'm just wondering if in the case of if C-15 was here now and that happened, what would happen? The other issue is in Nova Scotia with the fisheries issue. And I watch this almost nightly on the news and thinking, the people are really stressed trying to get their rights met. So if we had C-15 for the Mi'kmaq people, how would that impact them, and what would be different in the outcomes that they would experience?
Thank you very much for your question. And of course, being a maritimer, I welcome questions from New Brunswick and Nova Scotia. We all know that if Bill C-15 is passed tomorrow, that doesn't make UNDRIP in and of itself law. It's not a document that, oh, here it is law. And we also know that there's problems with federal and provincial jurisdictional disputes and debates. That being said, however, vis-a-vis the international human rights law, legal systems, and community, the obligation falls on Canada. It doesn't matter how Canada organizes itself internally, federally, or provincially. The law is the law is the law, and once Canada adopts an international human rights obligation, that's incumbent on Canada. So while this is a piece of federal legislation, it's going to be a very strong signal to all courts all over Canada, whether or not the provinces have specifically implemented it or not, that this is the bare minimum human rights standard. And it would be pretty difficult for the province of New Brunswick with C-15 and UNDRIP now applying in, at the federal level to say, yeah, but in New Brunswick, we don't do human rights for Indigenous peoples. That simply wouldn't fly. I think they should all pass legislation, similar legislation, but if they don't, I don't think that hurts anything. I think that it's only going to help our situation, especially in New Brunswick, where we haven't had a lot of movement, and in places like Nova Scotia.
Senator Tanis.
First of all, let me say thank you to the witnesses, and in particular to Dr. Palmater. It's always a shot of electricity and urgency that comes with your testimony, and it does not go unnoticed or unappreciated by me and by so many other senators. I want to say thank you. I believe that the 95% of people who are not Indigenous, who sat down and read the United Nations Declaration on the Rights of Indigenous People, would be able to check off 95% of what's on there. And I believe that the only issue, the reason that there is continual harping about FPIC is because it's about the only thing that anybody can find fault with. I can't find fault with it. I mean, it is, as Jason, as you said, an outstanding document full of principles. I guess I have two things that I worry about, and one is FPIC, and one is territories. And what's a territory? And within FPIC, I have the worry of consent, although I completely buy into the idea of what consent could look like without it being a veto. And I totally agree. And Harold Calla, who we'll hear from later, has some very smart words around this. But who provides consent is the tricky piece. For a business person that has to put capital somewhere, create value, create jobs, can put it here with a clear set of rules or here with an unclear set of rules. My grandmother said, she said to one of her daughters who wanted to get married to a guy with no prospects, but he was good looking. She said, well, when you have nothing to eat, at least you'll have something to look at. And I worry about defining FPIC and territories. And the minister told us that we would get that done in the next 2 years. Is it doable? Could you just weigh in quickly? I've sucked up all my time.
Thank you so much for your comments. I really appreciate what you said. Here's the thing about FPIC. In terms of women's consent to have sex, yes means yes and no means no. In terms of medical consent, yes means yes and no means no. In terms of parental consent, for things as limited as school trips, yes means yes and no means no. Why have we impoverished consent or fear it only for Indigenous peoples when everybody else is allowed to consent? Thank you so much.
Dr. Palmer, you're very optimistic about the impact of C-15, but I think you've also been very critical about the government's level of commitment to implementing a range of bills, including C-91. We're still waiting for a languages commissioner, 2 years and running. C-92, I don't need to tell you about challenges there. And of course, S3, and you're very well familiar with the shortcomings there in implementing gender equality. We've heard that the drafting process of the action plan and implementing it will be a complex one. Do you have any concerns about that pattern being repeated with this bill? And if so, are there any implementation measures that you think would add a layer of accountability?
Thank you for the question. As anyone knows, on any federal legislation I've ever testified on, I've always raised significant issues and for the most part been opposed to them without significant amendments. So it's actually pretty significant that I'm here supporting Bill C-15, because the whole core objective is to get UNDRIP and basic human rights into law in this country. And yes, do I think Canada will end up fighting it if there's a different government or this government? Will they delay? Will they have their own interpretations? And yes, they already have a backgrounder on it where they try to purport what it will mean and what it won't mean before we've even entered the negotiation process. However, that doesn't detract from the tool in and of itself. And it's a tool to move the agenda forward. It's a tool to push. It's a lever. It's a legal lever. It's a political lever. And I think given the vastly outbalancing we have with Indigenous peoples suffering ongoing genocide and trying to push Canada, every single tool is incredibly powerful and we absolutely need it. And the whole point of the National Action Plan is to work out all these processes and figure out how we want to do things. And we may want to do things differently. The Inuit may want to have a commission. First Nations may want to have something else, different First Nations. And that's the whole point of it, to recognize our independent human rights in this regard, and to not use the fact that colonization in Canada has divided us into 634 First Nations against our will. We didn't do that. So Canada can't come back to us now and say, oh, it's too hard to talk to you all. Hey, you created this. We didn't create this. And we already have 634 First Nations with all their own band membership codes, election codes, bylaws. We already have that system. So we can't say it's going to be too complex if we start recognizing their own laws. We already have them. We're just talking about recognizing our nation-based laws, which actually be much simpler.
Thank you,
Thank
Dr. Palmer. I want to thank our witnesses for this afternoon. I want to thank Chief Smith and Alexa McLaren. My thanks to Mr. Madden and Dr. Palmer. Thank you for appearing with us. I now adjourn the meeting.
Thank you all so much for taking the time to watch this video and hear my analysis in my own words. I really appreciate our traditional Mi'kmaq values, which remind us to listen to the diverse voices, views, insights, and opinions of all of our peoples with an open mind, because everybody's voice counts. We might not always agree, but we are far more informed and empowered by hearing everyone's views. I'll be sure to post links to the original Senate video, as well as other YouTube videos that I did sharing the voices of other Indigenous experts and grassroots advocates on the issue. It's important that we hear everybody's voice, those that are supporting UNDRIP, those that are against UNDRIP, and everybody in between. Till next time, stay alert, warriors.